Good morning, sir. We'll begin the rounds as the other judge joins as well.
Good morning. I missed the good morning, Lordships. I missed the morning briefing.
No problem, brother. Look, very glad to see you here. Very glad to see you. Brother Justice Jayagumar is with us.
Good morning. Good morning, sir.
Acha, all the three judges have joined. I think with their permission, we can start.
Ma'am, about Senthil sir, I can't find him here in the meet.
Senthil sir has joined.
Minutes, reserving 5 minutes for rebuttals. Also, for the Honorable Bench reference, we have put the time split in the chat box. So, with the permission of the Honorable Bench, I invite Speaker 1 from the petitioner side to present their arguments. Thank you.
Yes.
Much obliged. The council will begin in 3, 2, 1. The council seeks permission to address the bench collectively as Your Honor.
Yes.
Much obliged, Your Honor. If Your Honor permits, the council would like to showcase the compendium on the screen. May it please this Honorable Court. This is Council number TL01P, appearing on behalf of the petitioners in the case of Miss Y versus State of Vitara, clubbed with Miss Y versus PNB News, further clubbed with Society for Medical Rights versus Samantha Hospital and Research Center, all under Article 226 of the Constitution. If Your Honor would permit, the Council would like to move on to a brief statement of facts.
Please.
Much obliged, Your Honor. Your Honor, Sumanta Hospital conducted an unauthorized transfer of Miss Y's fetus to an experimental artificial womb without her consent when she went into fetal distress. This unapproved procedure, pending ethical clearance, led to media intrusion, marital breakdown, and emotional distress. Miss Y was later denied an abortion, restricting her reproductive rights. SME argues that this violates clinical trial regulations, posing ethical and legal risks to public safety. If Your Honor permits, the Council would now like to move on to the issues raised.
Please.
Yes.
Much obliged, Your Honor. There are 5 issues raised before this Honorable Court today. Firstly, whether Miss Y can demand the termination of pregnancy under the provisions of the MTP Act. Secondly, whether the transfer of the fetus to AWT without the consent of the pregnant woman amounts to grave mental injury under the MTP Act. Thirdly, whether there is a violation of privacy and confidentiality of the patient and other stakeholders. Fourthly, whether the petitioner can invoke a private law remedy simultaneously with the public law remedy. And lastly, whether the transfer of fetus to the artificial womb without conducting proper clinical trials is violative of the drugs and cosmetic rules or any other laws. Your Honor, the first speaker will be addressing the first two issues, and my co-counsel will be addressing the last three issues. With the permission of Your Honor, the counsel would now like to move on to the arguments advanced.
Yes.
Much obliged, Your Honor. Your Honor, Miss Y's entire life was uprooted by one emergency procedure. Her fetus was placed in an untested, potentially harmful technology without her consent. Her privacy and bodily autonomy were all taken away from her. All of this was a direct consequence of Sumatra Hospital's unauthorized use of the AWT on the petitioner's fetus. This brings the counsel to the first issue at hand. The council would like to submit as the first issue that Miss Y can demand the termination of her pregnancy under the MTP Act. The council would like to present this oral argument in three prongs, which differs from the format used in the memorial. Firstly, the legislative intent of the MTP Act is comprehensive and allows for the termination of the pregnancy. Secondly, the opinion of the RMP was made in violation of the MTP Act. And lastly, the denial of the termination would constitute a violation of the petitioner's fundamental right to reproductive autonomy. Your Honor, the first sub-issue seeks to establish that Ms. Y's demands fall within the purview of the legislative intent of the MTP Act. The Act only defines abortion as a procedure to terminate a pregnancy by using medical or surgical methods under Section 2E. It does not talk about what constitutes a pregnancy, not limiting it to mean the existence of the fetus inside the mother's body. Going by the basic rules of statutory interpretation, as stated under G.P. Singh's Principles of Statutory Interpretation, the plain meaning of the word pregnant isn't apparent here. Thus, a strictly textual interpretation should not be used. Your Honor, the context in which the Act was framed must be kept in mind when applying it to such a novel situation. Furthermore, Your Honor, Roe v. Wade, which is a 1970s judgment, predicted the potential development of the artificial womb technology. While this judgment is now overturned, it has also cited the book L. Hellman and J. Pritchard, which also predicted the AWT. Hence, the lawmakers of Samrat had at their disposal various means to foresee the development of AWT. It can thus be inferred that the omission of the definition of pregnancy was deliberate as to keep it flexible and protect the rights of the mother as a beneficial legislation. Additionally, Your Honor, MTP is a remedial legislation. It aims to provide legal provisions for the safe and regulated termination of pregnancies, addressing public health concerns and women's rights. This type of legislation typically seeks to rectify issues related to unsafe abortions and promote women's health and autonomy. Hence, Your Honor, according to the Supreme Court in the case of Allahabad Bank and another versus All India Allahabad Bank Retired Employees Association, the remedial statutes are known as welfare beneficent or social justice oriented legislations, and such welfare statutes always receive a liberal construction. According to the statement of objectives of the MTP Act, the legislative intent prioritizes women's autonomy, mental health, and well being. X versus State of Delhi, Your Honor, encourages a purposive interpretation of the statute so as to not limit the reproductive rights of a woman. According to the Shantilal report, abortions must be allowed where the birth of the child causes mental illness to the mother. The recommendations of this report form the foundation for the MTP Act. In the present case, Your Honor, Ms. Y was denied an abortion on the grounds that the fetus was no longer within her womb. However, the Act does not impose any such requirement. The petitioner's unprecedented situation must be construed within the ambit of the Act as established by the law. The Council submits that Ms. Y is a pregnant woman under the MTP Act, and the novelty of the situation does not change the purpose of the Act. Since termination of pregnancy is allowed to ensure the well-being of the mother, the same must be ensured in this case, Your Honor. The Council would now like to move to the second leg of the argument, which is the opinion of the RMP.
Before we proceed to the next point, since you said that Medical Termination of Pregnancy Act is a purposive enterprise, and the purpose is the health and the body autonomy of the mother. To what extent would this body autonomy part be relevant? What insofar as the process that they propose to do now has nothing to do with the body of the individual at all. Further, if at all there is a reproductive choice that is vested in the mother, to what extent does it survive once the fetus is outside the body?
While Your Honor raises a very valid point, the Council would like to plead that the bodily autonomy is not the only factor present within the purposive intention of the legislation. The reproductional autonomy and the mental health of the woman are as important, Your Honor. Section 3, subsection 2(1) of the MTP Act says that if the continuation of the pregnancy causes grave mental injury to the woman, she is allowed to perform the termination of pregnancy. Hence, Your Honor, the bodily autonomy, while it may not be directly infringed in this case, her reproductive autonomy is being infringed. And her right to raise children under Article 21 of the Constitution is also being infringed upon, which the Council will also later discuss in upcoming issues.
So what is
Counsel,
yes?
adding to my brother just said, see, the moment it has come out of the womb, and it has been come out of the mother's womb, and then it is more than 20 weeks, it is having a legal right on its own. And where is your right to terminate comes there?
While Your Honor raises a very valid point, the Council begs to differ. Your Honor, the fetus in this case it is 18 weeks old, firstly, and secondly, Your Honor, the prenatal rights of a child are nowhere guaranteed or have been allowed under the Republic of Samrat. For example, under the Hindu Succession Act and the Transfer of Property Act and various other acts, the rights of a child are only accorded to the fetus after its live birth and not when it is prenatal or in its gestational period. Hence, Your Honor, no violation of the prenatal rights of the fetus are taking place. If Your Honor is satisfied with the answer, the Council would now like to move on to the second sub-issue.
Well, the answer doesn't take in the question that my brother had raised, because when Article 21, if at all you are insinuating towards that article, that has already vested in the fetus. At least if you look through a recent decision by the Kerala High Court in Intulegas Rejith versus Union of India, there the Kerala High Court has proceeded to differentiate the individual rights that a fetus would have. Again, that has been categorized based on the age of the fetus. Well, maybe if it is maybe 1 month or 2 months, and if the fetus is 6 or 7 months, the situation is totally different. So based on even the age, or rather the stage of the fetus, stage would be the proper word, stage of the fetus, rights start vesting in it. So once it is out of the umbilical cord and the umbilical cord has been removed and it is on its own, and when the law says that it has acquired rights of its own as an individual or as a person, maybe, what is the sanctity in now saying that it has to be terminated merely because the mother has a perceived rights under the Medical Termination of Pregnancy Act, and that has to be protected? So it is the rights of the mother versus the rights of the unborn or the fetus. That is where I guess that my brother wanted to have some clarification.
Yes.
While Your Honor raises a very valid point, the Council would like to state that the judgment of Indulekha, as stated by Your Honor, was based on the fact that the fetus was 31 weeks old. In the present case, Your Honor, the fetus is 18 weeks old and falls within 24 weeks as stipulated under the MTP Act. Furthermore, there are no rights accorded to a 18-week-old fetus under any legislations, and it is not a viable child in this case. Whereas in the Indulekha case, the fetus was viable and thus its rights were stated. In the present case, Your Honor, the fetus does not have rights under Article 21, whereas the mother has the rights to both have the choice to raise the child or to have children, and as well as her own bodily autonomy, which was infringed by the unconsented transfer, which will also be touched upon in the second issue, Your Honor. Your Honor, if that answer satisfies you,
Yes, proceed, proceed.
much obliged, Your Honor. The counsel would like to move to the second leg of the argument, which establishes that the opinion of the RMP in denying the abortion lacked good faith. Section 3 of the MTP Act requires the RMP to act in good faith, which entails considering all relevant circumstances before formulating an opinion. The RMPs in the present case failed to consider the totality of Miss Y's environment. This included severe mental distress arising from the transfer to AWT, privacy violations, ongoing divorce proceedings, and the uncertainty surrounding her parental rights over the fetus. Your Honor, the Supreme Court in the case of X versus State of Delhi dictated that mental injury must be construed in the context of common parlance. Hence, the RMP's denial of the termination was not made in accordance with the MTP and cannot be upheld. Under the third sub-issue, the Council would like to emphasize that reproductive autonomy and the right to health are integral to Article 21 of the Constitution of Samrat. Ms. Y's right to choose to have children and to access safe and legal abortions is protected under this law, Your Honor. Forcing her to continue with an unwanted pregnancy severely impacts her mental health. May it be noted that this whole situation is due to the hospital's unilateral and unconsented decision. Thus, one aspect of the petitioner's reproductive rights has already been snatched away from her, Your Honor. The Puttaswamy judgment, footnoted at number 22 of the memorial, has clearly held that the Constitution must evolve with the contemporary technological advancements to protect fundamental rights. The Council humbly pleads that Ms. Y be allowed to regain control of her life and, in consonance with Article 21, be allowed to abort. Your Honor, the Council thus reiterates that Ms. Y has the right to terminate the pregnancy under the MTP Act owing to, firstly, the primary legislative intent of the statute, secondly, the negligent opinion of the RMPs, and thirdly, the reproductive autonomy accorded to Ms. Y under Article 21. If Your Honor has no further questions, the Council would now like to move on to the second issue raised.
Yes.
Much obliged, Your Honor. The Council would like to move to the second issue for consideration and submit that the transfer of the fetus to AWT without the consent of the petitioner amounts to grave mental injury under the MTP Act. The Council would like to present this oral argument in two prongs, which differs from the format used in the memorial. Firstly, the unconsented transfer led to the deprivation of choice of Ms. Y, causing mental injury. Secondly, the exception of emergency cannot be applied here. Your Honor, the Council establishes that the non-consensual transfer of the fetus to AWT amounts to a grave violation of her bodily and decisional autonomy. The MCI regulations mandate that written consent must be obtained from a patient before performing any complex treatment. The BNS at Section 30 also permits medical interventions without consent only and only when all possible alternatives have been exhausted and proxy consent cannot be obtained. Your Honor, in this case, the fetus was transferred to AWT without obtaining consent from Ms. Y or her legal representative. The deprivation of her choice has resulted in severe mental distress, exasperated by various uncertainties about her parental rights. The future of the fetus is also dubious due to the experimental nature of the AWT, as it is prone to causing brain bleeds. The continuation of the pregnancy would only serve to aggravate this mental pressure and oppress her.
Counsel,
Your
your
Honor,
concern is that you are right. Consent has not been obtained, or you are very skeptical about that new AWT technology itself. You are not very clear that what will be the future impact of the child, because see, there are twofold. One is that if it is only the consent, then in the case of emergency, they need not wait for the consent. But if you are not sure that the future of the AWT technology is not tested, it's still under testing processes, so that that transfer is illegal. What is your main contest here?
Thank you for the question, Your Honor. The main contention here is both the consent and the future of the AWT. Firstly, Your Honor, the consent part has been established under the no exception to emergency sub issue in this very argument, which the council will be touching upon. But to briefly state, Your Honor, proposition at paragraph 7 reads that various medical professionals were consulted before the transfer occurred. If the respondents had enough time to do this, why wasn't any attempt to contact the family for consent made? Secondly, Your Honor, as per the MIT Technology Law Review, as well as the other AWTs developing throughout the world, it has been stated that AWT is prone to causing brain bleeds. And as no proper clinical trials were conducted, no ethical approvals were taken place, and it was untested. Thus, the experimental nature of the AWT itself violates many legal provisions, such as the Drugs and Cosmetics Act, which has been discussed under Issue 5. If Your Honor is satisfied, the Council would now like to proceed with the argument.
Yes.
Much obliged, Your Honor. The Council would like to analogize the removal of the fetus from the petitioner's body with the practice of organ transplantation. Your Honor, Section 3 of the Transplantation of Human Organs and Tissues Act dictates that consent is required even for the extraction of organs from a dead or brain dead person. Such transplants are also life-saving procedures for people, Your Honor. But consent is not compromised in any situation. Why is it then that no consent was obtained from when the decision to empty Miss Y's womb and transfer her fetus were taken? The rights of a pregnant woman were placed below the standards afforded to dead patients. Your Honor, this procedure very heavily impacted Miss Y's mental health. Thus, the petitioner must be allowed to terminate on the grounds of grave mental injury. The Council submits as the second sub-issue that even if the hospital claims that the emergency necessitated the procedure, such waivers apply only to legally approved and established treatments, as was mentioned in the case of Jacob Matthews versus State of Punjab. Your Honor, the AWT procedure is still in its experimental stage. It lacks necessary approvals and research-based validations. Therefore, proceeding with such an experimental intervention without consent constitutes a violation of established medical norms. It further contributes to Miss Y's mental distress. The doctors had no way of knowing what the consequences of using the technology in that situation would have been. The respondents acted on a Hail Mary, which cannot be encouraged under the law, Your Honor. Condoning such behavior could lead to widespread medical malpractice. It is thus humbly submitted that the exception of emergency cannot be applied here. In light of the above submissions, the Council prays that this Honorable Court recognize the non-consensual transfer of the fetus as a grave mental injury under the MTP Act and allow Ms. Y to terminate her pregnancy. As, firstly, it will, does Your Honor have any questions?
Yes, counsel, it is done for your benefit. If it is not done, the harm caused will be more. It is for your benefit. The doctors have, in such an emergency, they were resorted to do that. If that is not done, your mental agony will be more. So why should you be placed in such a mental distress and claiming compensation?
While Your Honor raises a very valid point, the Council begs to differ. Your Honor, fetal distress is a very common occurrence, and a lot of other alternatives are available, such as O2 suctioning, intubation, resuscitation, NICU, etc., etc. However, Your Honor, the respondents in this case decided to transfer the fetus to an untested and unregulated technology, that too without the consent. That in that case, Your Honor, the exception of emergency cannot be applied, and even if it was done for the benefit of the mother and the child, more legal and medically approved alternatives were available.
Here the doctors has done in good faith. They are protected under the MTP Act. If he has done with something with good faith, they have to be protected. Is it not so? For the welfare of the mother and for the welfare of the fetus. So how they can be blamed for that?
Your Honor raises a very valid point, but the council begs to differ.
Yes.
Your Honor, firstly, the council would like to request an extension of 1 minute to address your concerns as well as conclude.
Yes.
Much obliged, Your Honor. Firstly, under sections 27 of the BNS and section 37 of the Drugs and Cosmetics Act, it has been stated that good faith is an exception. However, only for legally approved procedures and medically approved procedures. Furthermore, Your Honor, in Jacob Matthews versus the state of Punjab, it was stated that the
This is
Bolan
a new invention. So there may not be any precedent here. This is first time done. So there may not be any precedent, any approved practice. This is the first practice as of its kind, as per the case, as per the facts cited here. How there can be a precedent? Whether any precedent should be applicable in such a case?
Your Honor, while Your Honor raises a very valid point, as there are no precedents, and that is a point that the council is trying to make, that due to the novel nature of this technology, the hospital should have taken approved procedures and not acted on a Hail Mary when they did not know what could have gone wrong. Furthermore,
There
Your
will be
Honor,
no approved procedure. This is first time. First time it is introduced. And what is the purpose of introducing such an innovation? The purpose is for the public good, not for the good of yourself or myself, or it's for the public good. This hospital is developing such a new technology with the help of AI, benefit of the country, benefit of its citizen as a whole. So you are only instrumental to it. Due to such emergency, you have served the society. How can you claim compensation then?
Your Honor raises a very valid point, and for this, the council would like to cite the case of Jacob Pulliel versus the Union of India, wherein the COVID-19 vaccines, which were also a new technological advancement done for the public good, were injected in people without approved clinical trials, Your Honor. In this case as well, no clinical trials took place. Your Honor, the benefit does not take over the legal and medical procedures that have been established under the law of Republic of Samrat. Hence, even in the case of Jacob Pulliel, Your Honor, the court did not uphold the untested vaccines and injection of the vaccines.
Yes.
If Your Honor is satisfied, the council would now like to conclude the argument.
Conclude. You can conclude.
Much obliged. In light of the above submissions, the council prays that this honorable court recognize the non-consensual transfer of the fetus as a grave mental injury under the MTP Act and allow Ms. Y to terminate her pregnancy as it was a violation of her decisional autonomy and the defense of emergency is inapplicable here. With this, the council concludes the initial part of the argument. My co-counsel will now proceed with issues 3, 4, and 5.
Yes.
Thank you, Counsel. If Your Honour permits, the Counsel shall argue the third, fourth, and the fifth issue. The Council respectfully submit that the third issue at hand is the violation of privacy and confidentiality of the patient and other stakeholders. This issue would be presented in a three-pronged argument. First, Ms. Y's right to privacy was violated. Second, individual dignity should have been prioritized over public interest. And third, PNB News failed to adhere to ethical journalism standards, violating media ethics. The first sub-issue, Your Honour, establishes that under Article 21 of the Samrat Constitution, Ms. Y's right to privacy was violated by PNB News when they disclosed her personal information, including her health data, without her consent. In R. Rajagopal versus State of Tamil Nadu, the Supreme Court ruled that the citizen has the right to protect their privacy in matters relating to family, marriage, motherhood, and childbearing. PNB News disregarded these protections and extensively reported on Ms. Y's personal and medical details without her authorization, turning the case into a sensationalized media spectacle. Furthermore, Your Honour, the Supreme Court has emphasized the importance of maintaining patient confidentiality. Yet, PNB News failed to consider the legal and the ethical implication of such reporting leading to severe consequences, which includes Ms. Y's deteriorating mental health, a direct impact on her marital status, and the subsequent request for the termination of the pregnancy. Given the sensitive nature of the medical records involved, the media was expected to uphold a higher standard of confidentiality, which it failed to do so. Thus, Ms. Y's right to privacy and confidentiality was violated by PNB News. If Your Honor is satisfied with the argument, the counsel would like to move with the second sub-issue.
If you can hold on, what is the sphere within which a media can function, or whether it can disseminate details, especially when this is a matter, as my brother was pointing out, a unique one, something that has not been encountered before. And it is not as if that these informations that the media has now put forth are available to them directly. They are culled out from the information that is provided by the hospital. So, insofar as there is a larger public interest in knowing about such a technology that is available and the consequences of using it, as you yourself would contend that this is something that you were not aware of, your information was not sought or your consent was not sought, doesn't the general public have a larger interest in knowing about this? And was not the media only catering to that interest with the public have in such matters?
Your Honor raises a valid question. The question, Your Honor, has been argued in the second sub-issue. If Your Honor permits, the counsel would like to move on to the second sub-issue of the argument, which contemplates that the public interest does not override an individual's right to privacy.
Yes.
Much obliged, Your Honor. Your Honor, privacy is a dynamic concept that must be evaluated in context. In the present scenario, the unauthorized dissemination of Ms. Y's medical information resulted in the significant harm. As per our clarification, number 17, it for the information was itself was unauthorized and not legal. Even if the news was of an unprecedented nature, the press had a duty to anonymize the information to protect Ms. Y's identity and dignity. Public interest reporting must be balanced against the adverse impact on the individual's fundamental rights. In this case, there was neither any immediate risk to another, nor there was a matter of state interest that warranted the disclosure of private medical details. Furthermore, Your Honor, PNB News cannot claim a defense of larger public interest, as the violation of Ms. Y's privacy far outweighed any perceived public benefit. The media agency had a duty to exercise discretion and sensitivity. Instead, it acted recklessly, amplifying Ms. Y's distress and violating her constitutional protections. If Your Honor is satisfied with the answer, the counsel would move to the third sub-issue.
Yes, if at all there has been an infringement by the media into your rights, what is the remedy that you seek now at this point of time?
Your Honor, the counsel the question wasn't Your Honor, repeat the question, please.
If at all there has been an infringement of your rights by the media publication, what is it? What is the remedy that you are seeking now at this point of time?
While Your Honor raises the valid point, the remedy that the counsel thoughts for the petitioner is that the PNB News violated right to privacy, aggravated her mental distress, making it liable to damages for the same, and stop all reports on the matter immediately. Further, public apology would also be necessitated, Your Honor. If Your Honor is satisfied with the answer, the counsel would like to move to the third sub-issue.
No monetary compensation sought.
Sorry, Your Honor.
No monetary compensation, no damages, no monetary compensation.
Yes, Your Honor.
Having gone through this
Yes, Your Honor.
divorce and all those as a consequence of this, what is the monetary? Are you seeking a monetary compensation, or can it be sought in a 226 petition?
Your Honor, the counsel is seeking monetary compensation for the client, as further the right of the client has been violated. fundamental right, and further, it has already also discussed under the fourth issue of the written
Yes,
submission.
yes.
Much
Right.
obliged, Your Honor. Coming to the third and fourth sub-issue, PNB News failed to adhere to ethical journalism standards while reporting extensively on the case at hand. The Press Norms 2022 explicitly mandate that the press must uphold the right to privacy and refrain from any form of intrusion unless justified by genuine public interest. Additionally, Your Honor, ethical journalism guidelines require that the medical cases be lawfully sourced and reported with the consent of the patient. In the present case, NB News failed to comply with these standards as the information published with Ms. Wai's consent coverage did not adhere to lawful sourcing requirements as the news itself was leaked by the hospital. Third, the press failed to justify its inclusion as serving an overriding public interest. By failing to comply with these ethical and legal obligations, PB News engaged in unjust of both constitutional protections and established press. Furthermore, Your Honor, even if this data of the hospital or the medical records were leaked by the hospital, the family matter publication still remains a question on how the matter was sourced to the media agency. If Your Honor satisfied with the argument, the counsel would like to conclude the third issue.
There were so many mass media reports have come. Why was chosen specifically PNB News here?
I'm so sorry, Your Honor. Due to some network error, I'm unable to hear the question.
There are so much. The problem is there are so much mass media reporters to real estate, but why you have only chosen the PNB News agency alone?
I think it's been in a very
Can you hear me now? Counsel, can you hear me now? I'm not able to. You have to unmute yourself. The question is like, why PNB News Agency alone when it is reported in all the media?
if the can someone on the OC please clarify if the question is audible or not? Is the error on the part of the counsel?
Yes, the question is, why are you pinning down this particular media institution alone when insofar as that was there across the entire media? Why PNB?
Your Honor, this is a valid question. Your Honor, Your Honor, it is a valid question. In the present case, Your Honor, PNB News is a state-run media having a higher onus on protecting Ms. Wai's fundamental rights. Furthermore, as per the prop itself, PNB News did extensively on the matter itself regarding the publication of family details and private affairs of Ms. Wai.
So that is precisely because the state run is not a profit motive. So as my brother let's just say it is a new technology. In order to promote it, in order to take it to the masses, the state run agency is focused more on that. Is it not a valid defense for them?
PNB News has a higher standard to uphold the right of Ms. Wai as further it being a state media. Furthermore, the issue of public interest should not arise as there was no harm to any on there was compelling state interest.
Please proceed.
Your Honor, apologies, Your Honor. My co-counsel, due to some technical glitches, has left the meeting. If Your Honor would provide a few minutes so that we can sort out the issue.
Your Honor, due to a technical glitch, my device isn't working. If Your Honor permits, the counsel would like to argue from the speaker one's device. Yes, Your Honor. The counsel respectfully submit that there can be a simultaneous invocation of private and public law remedy. This is addressed through two key arguments. First, there is no bar under the written law. And second, of the pleadings. The establishes there is no bar written preventing parallel proceedings. Private law and public law operate legal implications. Public law remedy in the present case, Your Honor, is availed by SME, availed by SME against the High Court of against the state in High Court of Vitara, whereas the private law remedy here is filed by Ms. Y against the Sumantra Hospital in the State Consumer Court Commission. Sumantra Hospital, as a state-run institution, Your Honor, is subject to Supreme Court standard and is a necessary party to SME's writ petition. In Chairman versus Railway Board versus Chandrama Das, the Supreme Court has emphasized that even when damages are sought under the private law, public law remedies remain available for issues involving public officials and violation of fundamental rights. Similarly, both the Consumer Protection Act and the Constitution implicitly allows parallel proceedings under different issues. Section 100 of the CPA explicitly state that the provision, in addition to and not in derogation of any other law in force, affirms the constitutional remedies and do not include constitutional remedies. Thus, no statutory provision prevents the parallel legal actions in the present case concerning the unauthorized transfer of the fetus to AWT. If Your Honor is satisfied with the argument, the counsel would like to move to the second sub-issue.
Yes, go ahead.
Much obliged, Your Honor. Your Honor, under the second leg of the argument, the petitioner further admit that the proceedings against the Sumantra Hospital in both Consumer Commission and the High Court of Vitara are legally permissible and necessary, given their distinct subject matter and relief sought. The State Consumer Commission and complaint is based on medical negligence and the lack of informed consent seeking compensation for personal grievances of Ms. Y, whereas the writ petition by Ms. Y filed against SME raises broader constitutional issues such as privacy and bodily autonomy, seeking declaratory and injunctive relief against the public institutions and the state. Moreover, the standard of proof in both the proceedings differs significantly. Legal principles dictate that different courts and tribunals must be permitted to adjudicate different aspects of the legal dispute when relief sought varies substantially. Unlike the CPA complaint, which primarily concerns consumer rights, the High Court focuses on the public law issues, ensuring state accountability and enforcement of fundamental rights. Accordingly, both proceedings must be allowed to continue concurrently as they serve distinct legal functions essential for the full and fair administration of justice. If Your Honor permits, the counsel would like to conclude.
We couldn't understand, or we couldn't understand the dictum that you just read out from the screen. What summarize it to us for us? What is the dictum? What is the ratio decidency in that decision?
Your Honor, on the compendium, it is presented section 151 of the CPC, that is saving of inherent power of the court. Nothing in the court shall be deemed to limit or otherwise affect the inherent power.
What is the relevance of CPC in writ proceedings?
Your Honor, in the present case, the relevance of the CPC remains that the Consumer Commission the High Court should be allowed to hear the writ petition by SME, and the Consumer Commission filed by the Ms. Y should be held concurrently and parallelly.
What does that mean, concurrently and parallelly? How can there be such proceedings?
Your Honor,
There's no clarity in your submissions, madam. Please clarify it to us, that is all. We just want to understand the point that you are aiming at.
Much obliged, Your Honor. Your Honor, in the present case, the action that has been filed by both of the parties demand different remedies. The action filed by the SME against the state itself is regarding the violation of drugs and cosmetic rules, ICMR guidelines by the Sumantra State Hospital, whereas in the issue filed by Ms. Y against the Consumer Commission is
regarding the medical negligence and informed consent. In the present case, the state there is a distinct filing of the nature itself. Therefore, the court should allow the parallel proceedings of both the matters. In the present case, the High Court has stayed the proceedings in the Consumer Commission.
Counsel, your submission is that the High Court ought not have stayed the proceedings before the commissioner, consumer commissioner. That is your argument. High Court has got ample powers under 226 of the Constitution, especially when the legal issue comes like this. Isn't it?
Yes, Your Honor. But, Your Honor, in the case, the Chandrama Railway versus Chandrama Das allows
counsel, you are taking advantage of a occurrence of a thing in your life. Due to emergency, you want to take advantage of that and you want to get compensation. Huge compensation you are claiming, 5 crores of rupees. You want to take advantage of the situation. For private advantage, you are using it. Isn't it?
While Your Honor raises a valid point, but the counsel will beg to differ. Here, Your Honor, the fundamental rights of the patient itself has been violated, and then there is a medical negligence and the absence of informed consent. For moreover, Your Honor, 5 crores under the State Consumer Commission is a remedy which has been sought by Ms. Y, which in the present case is applicable because of the medical negligence and an absence of informed consent.
Counsel, we cannot understand what is the negligence herein. What is the medical negligence you allege? We can't follow that.
Your Honor, this has been further addressed in the issue 5 of the argument. But if Your Honor permits, for the counsel would like to the 5th issue and summarize the negligence of the hospital.
Before you go into the 5th issue, regarding that 5 crore compensation that you have sought, first and foremost, can any compensation be granted in a writ petition? Which are the decisions? What is the legal position on the point? And why 5 crore? Why not 10 crore? Why not 8 crore? Why not 2 crore? What is the basis on which this amount has been computed or quantified?
Brother Shyam, I think she has claimed compensation from the Consumer Commission, not from the High Court.
Not from the High Court. Okay.
Yes, Your Honor.
Yes.
Your Honor, the 5 crore compensation has been asked by Ms. Y in the Consumer State Court, whereas in the SME has asked for compensation.
No compensation claim from the High Court.
From High Court, not from High Court.
Yes.
That is why she objected the stay by High Court of the proceedings
Of the Consumer Commission's
Commission.
proceedings. Yes, I stand corrected. Yes.
If Your Honor permits, the counsel further presents that there was a claim by the claim under the writ petition in the High Court. Furthermore, if Your Honor consents, the counsel would like to move to the 5th issue at hand.
Yes.
If the counsel would like to move to the final issue at hand, and that the transfer of the fetus to AWT without conducting proper clinical trials is violative of the Drugs and Cosmetic Act and other laws. This argument is structured in 4 sub-issues. First, the use of AWT without conducting proper clinical trials violated the Drugs Cosmetic Act and the rules. Second, the transfer of the fetus to AWT violated other laws and international guidelines. Third, remedies for the violation arising from the unlawful clinical trials and experimental use of AWT. Fourth, in arguendo, the exception of the emergency does not apply. Coming to the first sub-issue, the counsel submit that the transfer of fetus to AWT amounted to the violation of the drugs and cosmetic rules. AWT, Your Honor, comes under the definition of drug under the Drugs and Cosmetic Act, as it intends to treat, prevent disease or disorders in human beings, including both the fetus and the mother. Additionally, under the Act, any new and experimental technology used for human treatments falls under the definition of a clinical trial. The transfer of Ms. Y's fetus to the AWT was not a routine medical procedure, but a systematic and deliberate application of an untested or hallmark of clinical trials. Furthermore, if Your Honor permits, the counsel would like an extension of 5 minutes to summarize the last issue.
I think 5 minutes would be more. We will grant you 2 minutes.
Yes.
Much obliged, Your Honor. Your Honor, coming to the second sub-issue, The fetus transferred to AWT violated not only Drugs and Cosmetic Act but also several national and international guidelines, which includes good clinical practices, which are binding under the ICMR guidelines, requiring regularly compliance in clinical trials, Declaration of Helsinki, which mandates explicit informed consent for medical examination, which is binding under the Drugs and Cosmetic Act. Furthermore, the ICMR guidelines prohibits unapproved trials in India, and Article 7 of the ICCPR forbids non-consensual medical experimentation. By failing to obtain Ms. Y's consent, the respondents violated multiple national and international legal frameworks, rendering the entire procedure ethically and legally invalid. Furthermore, Your Honor, Samrat's legal current framework lacks clear penalties for unauthorized clinical trials and medical negligence of this scale. While the drugs cosmetic rules provide oversight, they fail to address the penal consequences for unapproved experimentation. However, the absence of explicit legislation should not deny Ms. Y the justice. Under Article 226 of this Honorable Court, has the authority to halt further unauthorized trials involving AWT, declare Ms. Y's clinical trial unlawful, and award fair compensation for their unwilling participation in an unauthorized experiment that violated her bodily autonomy and fundamental rights. Judicial duty to protect fundamental rights must override the regulatory gaps. Therefore, Ms. Y must receive redress, and stringent legal directives must be issued to prevent future violations. Furthermore, Your Honor, the fourth sub-argument has already been covered by my co-counsel regarding the exception of emergency. It does not apply. If Your Honor permits, the counsel would like to move to the prayer. Wherefore, in the lights of the facts stated, issue raised, and authorities cited, the petitioner most humbly and respectfully requests the Honorable Court of Vitara to declare and adjudge that, first, Ms. Y is allowed to terminate her pregnancy under the MTP Act on the grounds of mental injury caused due to by the pregnancy of the fetus. Second, that PNB News has violated Ms. Y's right to privacy and aggravated her mental distress, making it liable to pay damages and for the same and stop all reporting on the matter immediately. Third, that both the private and public remedies are actionable to proceed against Sumantra Hospital and the case of before the Consumer Commission to be continued. Fourth, that Sumantra Hospital act of transferring the fetus into AWT without proper consent and clearance is in violation of the Drugs and Cosmetic Act and other laws of the Republic of Samrat, and the hospital must direct compensation to Ms. Y for the violation of her rights and pass any order or decree in the favor of the petitioners it may deem fit in the ends of justice, equity, and good conscience. It was a pleasure to argue before the Honorable Court.
Yes.
Yes.
The counsel for the respondent seeks permission to approach the dais and collectively address the benches, Your Lordships.
Yes.
Much obliged. Your Lordships, we are representing the respondents in the case of Miss Y and another versus Sumantra Hospital and Research Center. Your Lordships, if you all are well versed with the facts of the case, would it be okay if the counsel proceeded with the arguments advanced?
Yes, do that.
Much obliged.
Yes.
Much obliged. Your Lordships, as Counsel 1, I'll be dealing with the first and second issues, and my co-counsel will be dealing with the third, fourth, and fifth issues. Proceeding with my first issue, Your Lordships. The first issue deals with whether Miss Y can demand termination of pregnancy under the MTP Act, Your Lordships. I will be making threefold submissions here, Your Lordships, to prove that this is what it is. The first submission that I'd like to put forth is inapplicability of the MTP Act for the artificial womb technology. Why the counsel says so, Your Lordship, here is, according to the Oxford Dictionary, pregnancy is defined as having a baby or a young animal developing inside her body, Your Lordships. Why the counsel is taking refuge under Oxford Dictionary is because nowhere in our legislations has a explicit definition of this been given, which is why here we can compare it to para 11 of the facts, where it has been mentioned that evidently the termination of pregnancy was declined
on the sole ground that the fetus is now outside the womb of the mother, and hence we humbly submit that it would be impracticable to apply the current termination provisions for this unprecedented situation that the client of the petitioners is going through. The second submission the council would like to put forth is the grounds for termination of pregnancy is not satisfied by the petitioners. Your Lordship, why the council says so is firstly because there are two sole grounds under which the petitioners can seek refuge. The first ground is under Section 3, Clause 1, that the continuance of pregnancy would involve a risk to the life of the pregnant women or give her grave injury to either her physical or mental health. And the second refuge they can seek is clause 2 that says there is a substantial risk that if the child were born, then it would suffer from any serious physical or mental abnormality. Your Lordship, the respondents submit here that neither are satisfied. I shall substantiate the same by addressing each one individually. The first one I'll be addressing, Your Lordships, is there is no grave injury to the physical health of the mother. Why we say so is because the fetus has been removed from the mother's womb and has been placed in the technology. Hence, there is no harm to the mother as of the facts of the case and the technology concerned. The second submission the council would like to make is whether there is a grave mental injury involved. Your Lordships, the MTP Act itself, MTP Act Section 3, Explanation 1 and Explanation 2 clearly give us grounds for when we can consider grave mental injury has occurred. The first explanation says, suppose a pregnancy occurs as a result of failure of any device or method. Here referring that to contraceptives, Your Lordships. And the second explanation is pregnancy is by the pregnant women and it's caused due to rape or sexual assault. Your Lordships, drawing parallel to the case at hand, Miss Y hasn't been victim to either. Neither did they have a failed contraceptive, neither was the pregnancy due to a rape situation. It was a consensual married relationship that caused the pregnancy to occur. The next submission.
Sorry to interrupt you. You can't say that there is no physical injury or psychological harm that will happen to the mother because only the womb has been transferred to the artificial womb. The fetus has been transferred to the artificial womb. But the mother has to be provided all the medications as if the baby is grown there because who will take care of, who will feed the infant until 6 months or 3 months? The machine cannot feed. If the machine feeds, then that will give trouble to the infant. So the mother has to be fed all the hormones as if the baby is inside, so that her cycle continues. Isn't it? How can you say that there is no physical harm to her?
Your Lordship, in response to that question, I understand the concern put forth, Your Lordship, but we would like to submit here that the artificial womb technology is a type of a biobag that has created an artificial amniotic fluid to keep the fetus sustained, Your Lordship. So during the period of gestation, the councils humbly submit that there will be no harm to the physical body of the mother or the mental body of the mother because she will be completely detached during the gestation period, Your Lordship. Post pregnancy, multiple other options are available in case the mother wants to relinquish her rights to paternity at the moment, Your Lordship. That is what is humbly submitted. If Your Lordships are satisfied with that answer, can I proceed with my next submission? Much obliged, Your Lordship. Your Lordship, the next submission I would like to make is substantial risk of childbirth. This was another contention the petitioners put forth. Your Lordship, the paragraph 5 of our fact sheet tells us about the working of the artificial womb technology procedure. Here it's stated that this allows the fetus to develop outside the mother's body, reducing pregnancy risks as well as complications. It also creates a controlled environment free from pollutants and allows AI systems not only to monitor the fetal development, Your Lordships, but also aiding the doctors to manage the diabetes and hypertension of the mother herself. So considering all of this, as well as considering the fact that in para 8, we have found that This hospital, our respondents, are the pioneers of AWT technology in the nation of Samrat itself. We believe that we will take good care of the fetus and no harm is there. No substantial risk is involved. That is humbly submitted. Proceeding to the next argument, Your Lordships.
No, we
Right.
have a problem there because Medical Termination of Pregnancy Act recognizes the right of the mother to terminate the pregnancy. Here the fetus is only 18 weeks old. It is a fact that the fetus has been removed and now it is in an independent setup and it might grow on its own, maybe with the assistance given by the hospital. But that still doesn't take away the right of the mother as far as and her autonomy goes, so as to decide as to whether she needs to have a child or not. Now, merely because you have this contraption which would even provide for the growth of the fetus independent of the mother, does that mean that the right to terminate pregnancy which the mother has been lost in its entirety? Because even law ascribes a person's status only to a fetus that is beyond the stage of 30 weeks or 31 weeks, subject to correction. This is only a fetus of 18 weeks. Whether it is inside the mother or outside in a contraption, the right of the mother to decide as to whether it should be terminated or not still should be vested with her. It is as part of her right under Article 21 to decide one way or another. So how can you say that once the fetus has been removed in its total infant, or rather initial stages itself, the mother loses all the rights that she would otherwise have under the extant law?
Your Lordship, in response to that, the Council indeed understands the concern put forward. But Your Lordship, I would like to rely upon this submission of mine where I say that the fetus, Your Lordship, is still at a pre-viable stage. Like Your Lordship has already pointed out, it is only 18 weeks. Your Lordship, 24 weeks would be the right viability age, viability being the ability of the fetus to survive outside the mother's womb. Now, Your Lordship, in this case, the fetus was highly unlikely to survive without any sort of intervention, given that its lungs, brain, or the other vital organs were underdeveloped and incapable of sustaining life outside the womb, Your Lordship. Drawing parallel to a landmark precedent, in the case of Parmanand Katara versus Union of India, Your Lordship, it was held very blatantly that whenever on such occasion a man, say of medical profession, is approached and if he finds that whatever assistance he could give is not sufficient really to save the life of the person, and if he sees a better sort of assistance before him, then the man in the medical profession shall take that instead. Your Lordships, if you would permit, I would ask my researcher to screen our compendium, then Your Lordships could look into the phrase that I'm quoting. Researcher? That is what the Council humbly submits. If Your Lordships are satisfied with this issue, can I proceed with my next issue, Your Lordships?
Council, the issue there is, again, you have taken the fetus out without consent, only to save the mother, right? That is your concern. Your concern was that. The mother is saved now. Then your duty ends there.
Your Lordship, to answer this, the concern is indeed valid, Your Lordship, but we believe that in multiple cases, the right to life of an unborn has also been prioritized, Your Lordship. Here, I would like to lean on to the precedent of Indulekha Srijit versus Union of India. Your Lordship, here it was observed that an unborn child has a life of its own and rights of its own, and the rights of the unborn are recognized by law. Your Lordship, in this case, towards the end, the termination of pregnancy wasn't allowed, Your Lordship. Also,
31 weeks or 33 weeks, beyond the viable stage, as pointed out. No application of Indulekha in the facts and circumstances of this case.
Your Lordship, to answer that, I would like to take...
Even according to you, it has not passed the viable stage. As long as it has not passed the viable stage, there is no question of it acquiring any right or you being mulcted with any responsibility to keep it alive. It is squarely within the rights of the mother, especially under the MTP Act, to decide as to whether the pre-viable fetus is entitled to survive or not. As my brother Senthil was pointing out, the trauma of the mother doesn't end merely because it has been removed from the fetus. It continues once it becomes maybe after 10 months or 12 months. She has to take the trouble, and all along the life, she has to take care of it as a child. Or maybe, if you, as you rightly said, she can even disassociate with the child, but still she remains the mother. So why should she go through this trauma as far as the law protects her for a period, at least till the viable stage, to decide as to whether the child should be there or not?
Indeed, Your Lordship, in response to this valid concern of yours, I would like to take you to page 3 of my compendium, Your Lordship. Your Lordship, in page 3, we can witness the case of Cleveland versus Municipality of Anchorage. Your Lordship, this is a case that spoke about the viability of a fetus. If I could direct your lordships to the second paragraph that says viability indicates more about where the fetus can live than what it is. The fetus immediately before viability is not that qualitatively different from the viable fetus, your lordship. In addition, viability is very inexact a criteria because it is intimately connected with medical and scientific advances. And your lordships, in the future, it might very well be possible for the fetus to live in an artificial womb or even with an artificial placenta for a very early stage in fetal development. So your lordship, here I would just like to draw connection to how there is an intelligible differentia and nexus as to why we have conducted this operation. Your Lordship, our clients are also protected under the doctrine of necessity, Your Lordship. If Your Lordship permits, can I proceed with the doctrine of necessity as well?
Yes.
Much obliged, Your Lordships. Your Lordships, doctrine of necessity talks about one important maxim, that is quod necessitas non habet legum. Your Lordship, for this maxim to work, which simply translates as necessity knows no law, three elements have to be satisfied. The first element being prevention of a greater harm. Your Lordship, drawing parallel to our case at hand, there was a harm in the situation given to our respondents. They were in a situation where Miss Y fell and she was affected. She was rushed into the hospital, and our entire duty was to save both lives in complete entirety, Your Lordship. So the harm, greater harm that we moved away from was the loss of the life of the fetus. The second submission, Your Lordship, or the second key element is justification of the risk. Your Lordship, there is a fair and square justification because no other alternatives at the moment were viable to the team of exceptional doctors, Your Lordship. Hence, they acted on the client's behalf and decided that this would save her. The third submission or the third key element is good faith and absence of criminal intention. Your Lordship, again drawing parallel to our case, the client, Miss Y of the petitioners, was injured. Now, to save her, we did our level best. Your Lordships, this was no sort of any publicity stunt, or we did not want to impede her life or her fetus's life. The major thing we tried to do was save both lives at hand, Your Lordship.
Since you alluded to that publicity part, now we may have to read it along with that media reports also, where the media is flush with details of this individual as provided by the hospital. Now, as regards that necessity part, of the three elements of doctrine of necessity that you pointed out, we are very suspect. We don't take in that proportionality part very easily, because proportionality is one of those concepts that has to be taken note of when it comes to the doctrine of necessity. Because proportionality will have to take in the duty of or the rights of the mother also. Maybe you may be justified in saying that at that point of time you wanted to save the life of both mother and child. Subsequently, when it comes to the question of retaining the fetus in the contraption, the proportionality is rather doubtful, because the rights of the mother would overweigh that of the child. Now, coming to good faith, if you have this contraption already kept there ready so as to receive this fetus in the operation theatre, you ought to have informed the patient about the possibility of using it if at all a contingency arises. That has not been done. So the good faith part is doubtful. Secondly, since you have leaked all the private informations of the client to the media, the good faith totally ends. So necessity doctrine is totally unavailable to you.
Your Lordship, in response to this valid concern of yours, the part where this is not a publicity stunt will be dealt with in detail by my co-counsel. But in response to this, I would like to say that we did have good faith indeed, because our client, that the respondents were dealing, when the respondents were dealing with Miss Weiss, she was unconscious. Hence, at the moment, the most viable option to them was to save her life and the fetus's life, which was rushed into the AWT procedure. Your Lordship's also taking support of another test. Your Lordships, here I would like to direct you to page 4 of my compendium. In this, Your Lordships, Bolam versus Frame Hospital Management Committee, the Bolam test was identified, Your Lordship. In this, MC Nair J stated that a doctor is not guilty of negligence if he has acted in accordance with a practice accepted as proper by a reasonable body of medical skilled people in that particular art. Your Lordship, in the case of Bolam as well, they had not acted in a manner which was contrary to the expert opinion of their peers. Hence, Your Lordship, the council would like to submit that there were a team of doctors, be it the embryologist, be it the pediatricians, be it the gynecologist, everybody together conclusively decided that this was the right decision. Hence, we believe that nothing in arbitrary has taken place and falls under the doctrine of necessity. If Your Lordships are satisfied with that, can I proceed to my next argument, Your Lordships?
We cannot agree with the proposition of good faith, since you could have obtained the consent of some other near relatives. You had opted for that. That shows that you have done it with some malefites, so as to commercialize a new technology. You want to see this woman as an experiment. How far you are successful so far, and due to your commercial interest, you have made this woman as an instrumental to that.
Indeed, Your Lordship, the council does understand your concern, and in response to that, the council would like to draw parallel to the facts of our case, Your Lordship. Understanding that our respondents are the pioneers in AWT technology, and as well as they have a scientific committee in their research center, shows how we have followed the basic ethical rules in order to make our technologies develop in a proper ethical manner. So, keeping that in concern, we believe the good faith starts off from there, Your Lordship. Now, when it comes to the concern of consent, that will be dealt with by my co-counsel in detail. There is no doubt about that. But again, Your Lordship, I would like to draw parallel to the case of Parmanand Katara versus Union of India again, where it has been said that in the moment when there is not much time to act upon another decision, whatever the doctors believe is a better assistance to the victim on the table or the client on the table shall be taken upon by the medical practitioners. That is what is humbly submitted, Your Lordships. If Your Lordships are satisfied with that, may I proceed with my next part?
Yes, proceed.
Much obliged, Your Lordships. Lastly, because the time is up, Your Lordships, can I take a minute to sum up my arguments? Thank you so much.
Yes.
Much obliged, Your Lordships. So I would like to bring up the doctrines of parens patri, Your Lordships. Here, the state, in the case of Suchita Srivastava versus Chandigarh administration, has said that the state has the authority to act as the guardian of those who cannot represent themselves, such as unborn or artificially sustained children. Drawing parallel to our case, Your Lordships, we do have a child who is unborn, and we believe the state will make the right decision on behalf of our clients, Your Lordship. The court held that the state not only has a duty to protect the life of the pregnant women, and it also has the duty to protect the life of the unborn child, Your Lordship. The court further held in Suchita Srivastava that the right of an unborn child is not absolute, but definitely has to be balanced with the rights of the mother, Your Lordship. Furthering more, Your Lordship, just to give a conclusion on the interpretation rules that the learned petitioners had spoken about, the petitioners argued on how a purposive and beneficial legislation should be derived from the MTP Act. Your Lordships, I would like to take you to the compendium, page number 16. Researcher, please do. Your Lordships, this is the committee report, Shah Committee report on what is the objective behind the MTP Act. Your Lordships, here it has mentioned that the Government of India set up the Shantilal Shah Committee to decrease the high maternal morbidity and mortality associated with illegal abortions after deliberating on what has been happening over the past 2 years. Your Lordship, drawing parallel to this, moving on to the next part, I would like to draw a parallel to the short title or the objectives of our MTP Act itself. Your Lordships, the MTP Act explicitly mentions that the objective or the short title is an act to provide for the termination of certain pregnancies by registered medical practitioners and for matters connected therewith and incidental thereto. So, Your Lordship, the connection I'm trying to draw, the nexus is the purpose was not to give a woman her bodily autonomies in an arbitrary manner. The purpose was to give them legal abortion methods. And in the case at hand, Your Lordship, nowhere is the client of the petitioners in a position where they will have to illegally terminate their pregnancy. So their fetus is safe with us. And in a case as such, where this cannot be a nexus, we believe that it will not apply. Purpose of interpretation shall not. Your Lordships, why so is because in the Union of India versus Deonki Nandan Agarwal, it has been mentioned that even if there is a defect or an omission in the statute, the court cannot correct the defect or supply the omission as was held. Your Lordships, again, drawing the last parallel to a last case that I'd like to state, the Indore Malwa United Mills versus Union of India. Here, the Supreme Court again highlighted that courts are not entitled to usurp a legislative function under the disguise of an interpretation, as they must avoid the danger of determining the meaning of provision under a preconceived bias. With which I would like to conclude my submissions. If your Lordships have questions. If your Lordships don't have any further
In
questions.
the parents' patria jurisdiction,
Indeed.
it is a jurisdiction which has to be exercised in very exceptional cases.
Indeed, Your Lordship.
And there has to be justifications for using it also.
Indeed.
Now we are faced with a 13 weeks or 11 weeks old, 18 weeks old fetus. You have now developed a contraption wherein even an 18 weeks pre-viable fetus can be put into the contraption and grown into an individual. And you use the parents' patria jurisdiction also. So on the one side, you negate the right of the mother to terminate the pregnancy at a pre-viability stage. You have no authority whatsoever to thrust the state with parents' patria jurisdiction using this new contraption, taking out fetuses which the mother doesn't want and compelling the state to exercise the paternal jurisdiction, which is to be used exceptionally in very rare cases. How do you justify the contention regarding parents' patria in the facts and circumstances of this case, and which are the important decisions wherein the Supreme Court has laid down the limits of parents' patria?
Indeed, Your Lordship. To answer this question of yours, Your Lordship, the parents' patria decision was first and foremost highlighted in the landmark judgment of Sujita Srivastava. Your Lordship, here there was a mentally challenged woman and she was residing off of a government-run welfare institution. Here, because she was brutally raped and sexual harassed, she turned out to become pregnant, but the Supreme Court of India underscored the importance of a woman. It ruled that unless there is clear and immediate risk to the woman's life, her consent should be paramount and override her decision. Your Lordship, here I would also like to state that the parents' patria decision should be taken into force because in our Indian legislation or the legislation of Samrat, we don't have any stable right to life giving a fetus, that is an unborn child. It does have other rights, but not the right to life, and only the judicial precedents that exist so far provide that right to life can be given, which is seen in the case of Indulekha Shrijit versus Union of India, where the court has highlighted that the fetus should be given importance, which is why we believe that this is an unprecedented situation, Your Lordships, not just for the client as well as for the respondents, which is the hospital. So, taking a very haphazard decision arbitrarily.
And exceptional situations are not created. They just come out on their own, or they just happen on their own. Here is something that you created out of your own act for the purpose of maybe whatever benefits that you may get upon publicizing the fact that here is a new contraption that is a result of your science and technology experiments. Now, that's not an exceptional circumstance. Exceptional circumstance is as you rightly pointed out in the Supreme Court decision, where this is not something that could be assumed, or rather predetermined, or would have even intended to have happened. So this is not such a situation. This is a situation of your making.
We understand your concern, Your Lordship. It is very valid. But again, we would like to subtly say that another doctrine that would fall on our support would be the doctrine of substituted judgment. Your Lordship, this doctrine refers to the principle that in cases where a person is, say, unable to make decisions for themselves, and here that would be the client, Miss Y, another party is permitted to make a decision on their behalf, Your Lordships. Hence, I would also like to humbly submit, closing my arguments, that if today we decide to let the termination of pregnancy take place, Your Lordship, this will set a dangerous precedent for every further coming mother who wants to use the AWT technology, because they will be of the impression that they can relinquish their paternity rights while the child is in the gestation period. Another alternative that the respondents believe can be given to the clients of the petitioners is we keep the child, we don't terminate the fetus, we give her the psychiatric support she requires to go through it. And we also believe that once the premature baby is born, we provide it with the required relinquishment rights, that is, they terminate the paternity rights, and we can give up the child for abortion. That is what is humbly submitted and contended. With which I close my submissions, Your Lordship. If you're convinced, my co-counsel will proceed with the third, fourth, and fifth issues.
Yes.
Thank you so much. It was an honor arguing before you.
Thank you, Counsel. So if the Lordships are satisfied with my co-counsel's contentions, I'd like to move on to the issue 3, Your Lordships. Much obliged, Your Lordships. Your Lordship, issue 3 in hand is whether there is a violation of privacy and confidentiality of the patient and other stakeholders. Your Lordship, it is humbly submitted before the Honorable Court that there is no violation of privacy or confidentiality of the patient and other stakeholders, since the confidentiality of the patient's medical records are strictly protected under the Medical Council of India's Conduct of Ethical Regulations, Your Lordship. So this is purely an act of third party, which is the PNB used in the mass media. The Sumatra has no connections with the dissemination of the information regarding the private matters of the Miss Y, although the media highlighted the success of the case, the reason which will be substantiated in the further coming contentions. First one is the public interest supersedes right to privacy when it serves a larger public interest, Your Lordships. Your Lordships may please the Honorable Court. While the right to privacy is a fundamental right, it is not absolute and must be weighed against the duty to preserve life and protect the public health, Your Lordship. So, Your Lordship, I would like to draw a parallel for the case of Mr. X versus Hospital Z. The court upheld that when individual privacy conflicts with the public interest, the latter prevails if it serves a larger public interest, Your Lordship. So, Your Lordship, I would like to refer to the compendium for the umbrella term of the public interest, Your Lordship, which my researcher will be sharing in a few minutes. Researcher? Can you scroll up, Your Lordship? Your Lordship, as you can clearly see, the public interest here means the well-being of the general public first, and second, the attention of the people with respect to certain events, the general welfare of the right of the public that are recognized and protected and advanced, Your Lordship. So in this case, it's very pertinent that the procedure which is being used for the first time will be a precedent for all the across the world.
Counsel, please wait. you are seeking on the, you are relying on the doctrine of larger public interest.
Yes, Your
You
Lordship.
could have done this act even without hurting the privacy of the woman.
Your Lordship,
You could have very well done it without specifying the name or such other details.
Your Lordship, I'd like to answer to this question, Your Lordship. Much obliged. Your Lordship, in this case, Sumatra Hospital has no connection with the dissemination of information with the personal information of the patient, Your Lordship. Sumatra Hospital is protected under the ICMR guidelines and also the Medical Council Act. So it's nearly impossible for the Sumatra Hospital to disseminate any medical records of the patient without the purview of the ICMR guidelines or the Medical Council Act. So it is purely an act of the third party here, which is the PNB News and all the mass media who have reported extensively on the case, Your Lordship. So this has caused the right to privacy violation of this. So here the respondents who are the Sumatra Hospital has no connection with it, Your Lordship.
How you can take such a contention? Or it can be leaked out only from your hospital, Sumatra Hospital. You have done all these procedures.
Your Lordship, I am well aware of this, Your Lordship. Since Your Lordship, as I said before in my before contentions, the medical records, as I said before, it is protected by the Medical Council Act, Your Lordship.
Rather, you have a duty to maintain strict confidentiality of such details. You have failed in keeping such details in confidence. You failed your duty. You have failed in your duty.
Your Lordship, I would like to answer to this question, Your Lordship. Since the Lordships have mentioned the respondents have failed to uphold the duty of the confidentiality, I would like to go against it because since Your Lordship, in this case, there were in the factual metrics of the case, there were no mention that the Sumatra Hospital has leaked the information of the patients, Your Lordship. So it was purely an act of the third party. As you can see in the factual metrics of the case, Your Lordship, I'd like to direct the Lordships to the para 9 and 10 of the factual metrics of the case, Your Lordship, where it says that the mass media reported the story and state-run media agency PNB News extensively reported on the case. And detailed information about the situation has been telecasted, Your Lordship. So nowhere in this mentioned that the Sumatra Hospital are one of the contentions, like one of the parties who are disseminated the information, Your Lordship.
Council, have you read section 106 of the Indian Evidence Act, H2L Indian Evidence Act? A particular knowledge that is within your special knowledge. A fact is within your special knowledge. If it comes out, you have a duty to explain how it comes out, how it is leaked. That fact is only known to you within your particular knowledge.
Your Lordship, I would like to answer to this question, Your Lordship. Your Lordship, in this case in hand, the Sumatra Hospital has talked only about the AWT procedure, Your Lordship, not about the personal information or personal records of the patient in this content. Like the personal information was allegedly leaked only by the PNB News media, Your Lordship. So it is purely an act of the third party and it has no connection with the Sumatra hospitals. So Sumatra hospitals...
Can you wriggle out from the responsibility of the leakage of the information in a case wherein you have a fundamental duty to keep the strict confidentiality?
Your Lordship, I would like to draw in parallels with the 2.3 of the ICMR guidelines, which talks about the confidentiality of the medical practitioners, Your Lordship. So in this case, Sumatra Hospital has duly consented with the 2.3 of the ICMR guidelines, and they have maintained the confidentiality of the patient records, Your Lordship. So nowhere in the factual metrics it has stated that the Sumatra Hospital were one of the people who were involved in the leakage of the information. Your Lordship, it is purely an act of the third party to disseminate the information of the patients. It can be an investigative journalism or whatever, Your Lordship, but only the procedure of the AWT was being telecasted by the Sumatra Hospital, Your Lordship. So hence, I would like to go on with the arguments if the Lordships are clarified.
Yes, you proceed further.
Yes, Your Lordship. I'll be proceeding further. Your Lordship, the term public interest remains undefined in statutory law and is subject to informal interpretation. Your Lordship, I would like to draw on parallels with the case of R. Rajagopal and another the state of Tamil Nadu, The court acknowledged that the right to privacy is evolving and must be assessed by case analysis, Your Lordship. So the right to privacy and the public interest here is to be analyzed in a case by case analysis and should not be given an umbrella term or a clear defined term, which will affect the other precedents also in this case, Your Lordship. So, Your Lordship, moving on further with the arguments, the RTA Act does not define public interest. No other freedom of information law in the world does it. So, Your Lordship, I would like to draw on parallels with the Scottish Parliament debates on the Freedom of Information Bill. They stated that it was decided that any attempt to define the term public interest would limit its effectiveness and its potential application in future cases would impact, Your Lordship. So they haven't defined anywhere in the public interest in the Scottish Parliament. Hence, it should be a case-by-case analysis.
Definition of public interest is well charted out in Indian legal jurisprudence. So we may not have to go to the Scottish law on the point. Now the question is, looking at it from Puttaswamy case or subsequently the Kunal Kamra decision or Kaushik Kishore judgment as laid down by the Supreme Court. Whenever there is a conflict between the public interest and private interest, and maybe even between the private rights of an individual with the right to freedom of speech and expression from which the rights of the media or the press emanates, there is a need for the media rights to succumb or rather respect the private rights of the individual. As my brother was pointing out, notwithstanding the ICMR guidelines, when the details, especially the name, we don't have an issue with respect to the new contraption that you have invented and the benefits of that being published. When private confidential details pertaining to the individual, her name and her address and details are there in the public sphere, how do you justify it on the basis of larger public interest? Under which provision of law?
Your Lordship, I would like to answer to this question, Your Lordship. Much obliged. Your Lordship, under Section 8, Clause 2 of the RTI Act, it says that an public entity can disseminate the information, personal information of the patients or any other stakeholders when there is a clear identity of a larger public interest, Your Lordship. Though there are certain restrictions, Your Lordship. Under Section 11 of the RTI Act, it says that when disseminating an information that is a private information of the person, they should have gotten the consent of the CIPO, Your Lordship, which is the Central Information Public Officer and State Information Public Officer, Your Lordship. So in this case, as you can see, the procedure is an groundbreaking technology which has been availed by numerous amount of people. Your Lordship, since in this case factual metric says that Sumatra Hospital is an pioneer of the ART services, Your Lordship. So when they are inventing a procedure like the AWT technology, it will be an groundbreaking technology, and other persons from the world will avail this service, Your Lordship. So this is clearly an motive of publication of the procedure, Your Lordship, but not the personal information of the patients in this case, Your Lordship. So, Lordship, drawing in parallels with the Dr. Puttaswamy case, the doctrine of proportionality has also been discussed in this case, Your Lordship, where it states that it can be proportional when there's a larger public interest. So that's the reason why the public interest is being defined in this, Your Lordship. So if the Lordships are satisfied, the Council would like to move on with the further submissions. Thank you. Thank you, Lordship. Your Lordship, moving on with the further issues. The AWT procedures covered under the ambit of public interest, which is already been told. Your Lordship, I would like to draw in parallels with the case here in hand, which is Bihar Public Service Commission versus Syed Hussain Abbas Rizvi. Your Lordship, in this case, they stated that personal information, which is under Section 8 Clause 1 Clause J of the RTA Act, is exempt from disclosure unless justified by a larger public interest, which is well established in this case also, Your Lordship. Thus, Sumatra Hospital cannot be held responsible for any alleged breach of privacy or media disclosure. We respectfully seek appropriate relief from this Honorable Court, Your Lordship. If the Lordships are satisfied, the Council would like to move on with the issue 4, Your Lordship. I'd like to move on to issue 4, Your Lordship. Much obliged, Your Lordship. Your Lordship, issue 4 in hand here says whether the petitioner can invoke a private law remedy with a public law remedy simultaneously. Your Lordship, it is humbly submitted before the Honorable Court that the petitioners cannot invoke an private law remedy simultaneously the public law remedy, because the hospital comes under the purview of the state, your lordship. Since the hospital is a state-funded agency, it comes under the purview of state, your lordship. So seeking an alternative remedy in another court of law is again an abuse of due process of law. If the High Court finds whether there is an deficiency in the service, it has the power to grant compensation as well. So the Ms. Y seeking an private law remedy for deficiency of service is again an abuse of the power of the law. Hence, it is clearly stated in this argument, your lordship. So coming back to the arguments further, your lordship, under section 10 of the CPC, which talks about the doctrine of res sub judice, your lordship. So it prevents the court from proceeding with the trial if the same matter is already pending before a competent court. Your lordship, the factual metrics of this case revolves around two terms, which is the medical negligence, informed consent, and the right to privacy, your lordship. So if Ms. Y is depending on this, she can file only the writ petition in the court, and also without filing an petition in the private forum, your lordship. Thus, it is purely an act of wasting time of the court, I guess. So, your lordship.
That's an interesting argument. Res sub judice. What if the cause of actions are different?
Your lordship, if the cause of action are different, the entities
by the very nature of it, she had sought for compensation from the Consumer Commission. That is the proceedings that can be preferred only there.
Your lordship,
before this court. Here she is here to protect her constitutional rights and invoking her constitutional remedies. Does res sub judice apply in such a situation?
Your lordship, I'd like to answer this question. Your lordship, res sub judice applies in this case because your lordship, the factual metrics of the case, as you can see, which is in hand, talks about the medical negligence as well as the right to privacy, your lordship. So if Ms. Y is contending that her right to privacy has been violated and also there's a deficiency in service, she can invoke both the petitions in a single remedy, your lordship, because Article 226 has a broader purview. So the High Court has the power to grant compensation as well, your lordship. So going to separate forum and asking for compensation is clearly an abuse of the doctrine of justice, your lordship.
Counsel, these are two independent, separate and distinct remedies. What is wrong in pursuing private remedy and public remedy together? Of course, the High Court has got powers to grant compensation. There is a forum for deciding compensation, if at all any medical negligence. And what is wrong in proceeding in commission and at the very same time parallelly in High Court? What is wrong in it?
Your lordship, I would like to answer to the question, your lordship. Say if both the cases are done parallelly, there will be an obviously lead to a judicial redundancy, your lordship. So, and also informed consent falls under the ambit of the Article 21 right to privacy, your lordship. So with drawing parallel with the factual matters of the case, your lordship, so it revolves around the medical negligence. So why not Ms. Y seek an compensation in the public forum as well, your lordship? So if at all, your lordship, in worst case scenario, the petition is being in favor of respondents, obviously the petition is being filed in the private forum will be if the private forum gives against the respondents, it will be a clear abuse of law, your lordship. So henceforth,
there will be any conflict, because the private forum, for example, in our case, the Consumer Commission is looking into the factual aspects and granting a compensation of a huge amount. How much is it? 8 crores. Okay. How much is that? 5 crores.
5 crores.
Whereas when it comes to adjudication, or if at all, of course, damages can be, or a compensation can be granted under 226, but that wouldn't be based on an appreciation of facts. It would be rather a lump sum figure that has been looked into. So, as my brother was rightly pointing out, why can't there be a public and private remedy adjudication going hand in hand or at the same time? And merely because the High Court High Court decides, as you said, the worst situation where the High Court decides in favor or puts a decision, there is no question of that contradicting or in any way preventing the Consumer Forum from proceeding with the appreciation of facts and coming up with a compensation figure, if at all it finds it merits compensation.
Your lordship, I would like to answer to this question, your lordship. Your lordship, as the lordships were talking about it before with the petitioners, the asking for a huge sum of money, which is 5 crores for just for deficiency of service, is also, I mean, they can ask it, but in this case, Your Lordship, since the factual metrics revolve around the same issues, why they need to go for two different forums, Your Lordship, which is private law remedy as well as public law remedy?
Merely because they are entitled to in law, and there is no prohibition against them doing it.
Your Lordship, I'd like to answer this question because, Your Lordship, the High Court has the power to decide the case in a broader perspective as well. So, if the court feels there is a deficiency of service which is given by Sumatra Hospitals, obviously the High Court has the right to give the compensation as well, which has been discussed in this case.
We can as well dismiss her writ petition and permit her to proceed with her private remedy.
Your Lordship, since the Ms. Y has contended for writ petition which has been filed under the article right to privacy, obviously the right to privacy comes under the article 21. So they have to seek to the public forum. So when the case is going on in the public forum, if the judges feel that there is a deficiency of service which is being given by Sumatra Hospitals, judges have the total discretion of giving any judgments, Your Lordship, which is being pertaining to also the compensation or any other judgments in favor of both the parties or the single party, Your Lordship. The Lordships are satisfied. The council
both are public forum only. You are trying to say private law remedy and public law remedy, or you are trying to say it's a private forum itself?
Your Lordship, a petition has been filed in the private forum for deficiency of service and public forum for writ to writ petitions, Your Lordship.
Consumer court is a public forum.
Your Lordship, consumer court falls in the purview of the private forum, Your Lordship.
No, it is a public forum, as rightly said by SURANA Academy. It's a public forum. How can it be a private forum?
Your Lordship,
as per a special act, it is constituted. Consumer Protection Act. It's a public forum. It cannot be said to be a private remedy. It's a distinct remedy. A forum like a consumer commission can take more adduce. They can consider the evidence in a better way than the high court will do it. So what is wrong in proceeding in consumer forum and at the same time in the high court? Two separate jurisdictions.
Your Lordships, in this answer to this question, the petitioners have the power to can avail the compensation as well as the writ. Writ in favor of them if they approach in a single public forum as well, which is the High Court, Your Lordship. So going with two parallel forums, literally it's like affecting the due process of law, Your Lordship. So hence, the petitioners can file a single application in the High Court to substantiate this, Your Lordship. If the Lordships are satisfied, the council would like to move on with the arguments in that.
Yes, proceed. You can proceed.
Yes, Your Lordship. Your Lordship, moving on with the fifth issue, since there is an constraint in time, Your Lordship, moving on the fifth issue, whether the transfer of fetus to the artificial womb without conducting proper clinical trial is violative of the drugs and cosmetics rules or any other laws, Your Lordship. Your Lordship, it is humbly submitted before the Honorable Court that this rule provides a statutory safeguard to the doctors for protection of action taken in good faith. So I'll be moving on with the Clinical Establishment Act, Your Lordship, which has been put forth in this fifth issue, Your Lordship. Your Lordship, if you have the memos in hand, I'd like to direct you to page number 23, Your Lordship. 23. Subsection 3, Your Lordship, which talks about the Clinical Establishment Act 2010, Your Lordship. Your Lordship, it is humbly submitted before the court that Section 2, Clause D, Clause 1, the term emergency medical condition has been correlated, placing the health of the individual with respect to a pregnant woman. The health of the woman or an unborn child is in serious jeopardy, Your Lordship. So hence, it is contended that the situation faced by the team of doctors was an emergency situation. So it is a serious intervention. They have to put the fetus into a procedure to make it survive, Your Lordship. This is the main contention which we've been trying to make it by the Honorable Court. So moving on to
the issue there is, yes, in an emergency condition, you can react. That the law provides. But the reaction should also for a lawfully accepted procedure. The question here is that your ART technology, what is the AWT technology, is it legally validated one or not? If it is not legally validated, what what is the right you have to use that procedure. There are other procedures available in an emergency.
Your Lordship, I'd like to answer this question, Your Lordship, with your permission.
Yeah, please.
Much obliged, Your Lordship. Your Lordship, in this factual metrics of the case, they stated that Miss Y has suffered a serious fall and she was rushed to the hospital. So in that scenario, there were two lives involved, Your Lordship, the fetus and the mother, Your Lordship. So in this scenario, the medical practitioners are expected to react in a serious intervention. So they had no other alternative remedy available at that point, Your Lordship. So that's the reason why they put for this AWD procedure, which has already gotten the scientific approval from the committee in the hospital itself, Your Lordship. So they haven't not fully devolved with this case, Your Lordship, but they have put this baby in this procedure only because there is a scientific committee approval of the hospital itself. This is a contention which is being trying to make.
Is the Drugs and Cosmetics Act applicable to the procedures also, or only for drugs?
Your Lordship, the procedures and the drugs, Your Lordship, even for the devices used in the drugs.
But the devices defined, right? Is that your device is included in that?
Your Lordships, it's not included in the Drugs and Cosmetics Act, Your Lordships, but also AWT procedure comes in the ambit of ART procedure, Your Lordship. So it is mandated in this art procedure, in this in the Drugs and Cosmetics Act, Your Lordship.
Proceed.
Yes, Your Lordship. Much obliged, Your Lordship. Your Lordship, I would like to move on with the last leg of my argument. By that, I'll be ending with my arguments, Your Lordship. Your Lordship, moving on to the last argument, the ICMR guideline 2017, it is most humbly submitted that Section 12.2.8 allows deviation from standard protocols in emergencies, Your Lordship. So, when consent of the participant is not possible due to the situation, informed consent must be administered to the participant at later stage. In this case, the later stage, after the procedure has been done, the doctors have duly informed the family members as well as the Ms. Y after conducting the research, Your Lordship. So, henceforth, I would like to contend that the transfer of fetus to the artificial womb without conducting proper clinical trial is not violative, Your Lordship. So henceforth, I will be moving on with the prayers if the Lordships are satisfied with the arguments, Your Lordship. Your Lordship, can I move on with the prayers, Your Lordship?
Please.
Much obliged, Your Lordship. Your Lordship, wherefore the lights of the issues raised, arguments advanced, facts mentioned, authorities cited, the counsel for the respondent humbly prays that this honorable court may be pleased to hold, adjudge, and declare. This honorable court holds a provision for the MTP Act 1971 solely to focuses within the womb and do not extend to the artificial wombs. That this honorable court finds the transfer of the fetus to the artificial womb was a necessary life-saving intervention, does not constitute grave mental injury. This honorable court holds that the disclosure of information was incidental to the emergency and undertaken in good faith without any intent to violate the privacy and confidentiality. This honorable court holds simultaneous invocation of private and public law remedies impermissible as it leads to duplicity and ineffectiveness in legal process. The honorable court holds the transfer of the fetus was an emergency situation and undertaken to save the life of the fetus, Your Lordship. And or even dismiss this petition, pass any other order, writ, or direction which deems fit in the interest of the justice, equity, and good conscience. For this, counsel shall be duty bound forever, Your Lordship.
So with the permission of this honorable bench, I invite the teams with the rebuttals and sub-rebuttals.
A very interesting point is respondent, they are not simply saying you dismiss the petition. They are even asking for a declaration, saying that MTP Act will not be applicable to artificial wombs. That was not there in the original argument itself.
Your Lordships, the council are asking to dismiss the petition since the further contentions were made in the prayers as well. That's the reason why the council was asking for dismiss the petition, Your Lordship.
Right, please.
If Your Honor permits, the petitioners would like to start with the rebuttals. Much obliged, Your Honor. Firstly, Your Honor, the counsel for respondents has cited the case of Suchita Srivastav, but the ratio and the facts of the case were misstated, as the case talks about when the mother wanted the child. The ratio highlighted that the mother's consent and wishes must be placed foremost. In the present case, the mother does not want the child. How have the respondents used this case when it favors the petitioner's stance? Hence, parents' patriarchy rule cannot be applied here, as it can only be allowed in the rarest of the rare cases. An attempt to mislead the court through misstatement of facts was made. Secondly, Your Honor, the entire argument 3 of the respondent stated that the hospital did not disclose the information. However, clarification 17 clearly states that the hospital leaked the information. Hence, the news agency's acquisition of this information remained unauthorized and was an unauthorized source, violating press norms O42 and 5. This was also an attempt to mislead the court through misstatement and misinterpretation. Thirdly, Your Honor, the respondents have cited RTI as a defense for the disclosure of data in the memorial. Your Honor, Section 8IJ of the RTI clearly states that unless the Central Public Information Officer or the State Public Information Officer or the appellate authority permits and is satisfied that the larger public interest is justified, only then can such unwarranted disclosure of private information can take place. However, no such attempt to contact these authorities was made in the present case. Furthermore, Section 8.2 of the RTI again states that a public authority may allow access to information if the public interest in disclosure outweighs the harm to the protected interest. Could the respondents apply the three-pronged test of the K.S. Puttaswamy judgment and explain how the public interest outweighs the protected interest, as there is no legal source, no proportionate balance of rights, nor any immediate need? Fourthly, Your Honor, the respondents claim that no mental injury due to temporary distress exists, as there was no provided evidence of PTSD and clinical depression. Your Honor, mental injury, the word used in the MTP Act, differs from mental illness. Ex versus State of Delhi has stated that mental injury must be construed using normal common parlance and not technical medical terminology. Furthermore, Your Honor, the case of Srimati P. Ranjana versus Union of India, as well as the Act, Section 2 of the Mental Healthcare Act, states that the emotional upheaval, even if temporary, leads to mental injury. Thus, Your Honor, the Council fails to understand how the lack of symptoms of a particular mental illness establishes that there is no mental injury. Also, Your Honor, moving forward, page 12 of the memorial of the respondent states that the AWT was beneficial, but the Council fails to understand how any undoubtedly excellent technology, but in its untested, unregulated, and unsafe state, can be beneficial, which risks the future of all stakeholders. Moreover, the Bolam test applied by the petitioners, but the Bolam test was used in the case of medical practitioners consulted were all part of the hospital. Your Honor, how would an ordinary RMP have approved such a legally unapproved procedure when other post-operative options exist? There was also a risk of brain bleeds in this case. Hence, the Bolam test is not applicable here. Lastly, Your Honor, the respondents have again and again cited good faith as a justification. But they have used the MTP Act Section 8 for this justification, and they're also alleging that no pregnancy exists in this case, and the Act is not the provisions of the Act do not apply. So how are they using this defense of good faith? Furthermore, they have also used Section 37 of the Drugs and Cosmetics Act for good faith, but the language of the Act states that it is only applied for the acts done or intended to be done within this Act. Therefore, the trials should have been authorized, and they're claiming that the Act does not fall, that the Act is not to be applicable in this case. With this, the Council rests their rebuttals. It was an honor arguing before this court.
Yes.
The counsel for the respondent seeks permission to put forth the contradictions. Much obliged, your lordships. Your Lordships, I'll start answering one by one. The first one I'd like to address is how the Learned Council pointed out that we were trying to misdirect the court in the case of Suchita Srivastava. That was never the case, Your Lordship. All we tried to point out that the women's bodily autonomy was not kept in mind, Your Lordship. The life of an unborn child was kept in mind. The Supreme Court overturned the hearing of the High Court, saying that if the mother wants to keep the child, we will prioritize the life of an unborn child and let her keep it. Whereas the High Court had said otherwise. They decided that because of Suchita Srivastava's mental retardation, we will allow her to terminate the pregnancy. High Court overruled that and said, no, it's the life of the unborn child we will submit for. The next submission the council would like to make is the learned councils mentioned that we made a mistake in saying who disseminated the information. We did not, indeed, Your Lordship. We clearly stated that it's the hospital that gave out the information about the success of the procedure, and in parallel to the fact sheet, nowhere has it been mentioned that we have given out the biometrics or the personal demographic variables of the clients of Miss Y, Your Lordship. We have only said that the procedure was a success, and that is what the Learned Council is referring to in the clarification sheet, question number 7, Your Lordship. The next submission the council would make is the RTI Act was questioned, and as to how the various other authorities weren't checked with before publishing this information. Your Lordship, the learned councils are trying to bring in assumption of their own that we did not go and check in with the other authorities. The facts of the case have closed out and constructed us in a very constrict form of the facts where we do not go outside the parlance. We stick to the facts and we say, indeed not. What we have done is just given out the procedure. Dissemination of the news in extensive nature was done by a third party and not us, Your Lordships. The next submission I'd like to make
What
is
do
how,
you say about that Bolam test part which they contended?
indeed, Your Lordships. Your Lordships, the Learned Council spoke about how the Bolam test wouldn't apply to our case, but
Yes.
we would like to politely contradict to the same by saying that, Your Lordships, under the Parmanand Katara versus Union of India case, also it has been said that it doesn't matter what the situation at hand is, you need to save the life of the person. That is of paramount importance. So,
What is the Bolam test?
Your Lordship, the Bolam test is about when another learned medical practitioner is consulted with about the situation at hand. They also agree that what decision the other practitioners had taken is viable, Your Lordship. That is what is humbly submitted. We believe that in the case, there were a team of doctors that have put in their heart and soul to save the mother as well as the fetus, Your Lordship. Here, even if any other medical practitioner outside of the hospital, as the contentions of the petitioners council was, then also we would support ourselves saying that they would agree to it too, because if we were to let the fetus die, then again that would be a violation of our article 21 saying we could not save her fetus, Your Lordship. Proceeding to the next submission that I'd like to make, that is paragraph 5 clearly proves that, oh, indeed, Your Lordship. So here the learned councils mentioned as to how the AWT technology cannot be given any sort of guarantee or assertion to. Your Lordships, we would like to politely disagree because paragraph 5 of the fact sheet has explained in detail that it has maintained the stability of the fetus by giving it a very controlled environment, and it is alive as of date as well, and the mother is also being terminally interpreted through this device, Your Lordship. So since we are the pioneers, we believe we have done right by the clients that have approached us. Lastly, Your Lordship, the Learned Councils also brought up Section 8, which is in fact of Section 8 of the MTP Act, which is in fact in favor of us because any decision that the medical practitioners decide to take that actually ends up harming them, but it is in for a better condition, that is, it's for a bigger cause, then it would take away all sorts of liability from the doctors. That is what is humbly submitted. Lastly, Your Lordship, one last humble contention is the X versus Union of India had clearly stated that, in fact, it was Justice Chandrachud saying that we would not instill the heart of a fetus, because in Suchita Srivastava, they said that a fetus has life since conception being the embryo existence. And since our fetus is already an embryo, we would like to contend that Justice Chandrachud said you should keep the child and gave this duty on the AIMS hospital. So they said you take the liability of it, you let the fetus grow, and once they grow, you ask the mother to relinquish their parental rights and then give up the child for adoption. That is what is humbly contended. And with that, the council rests her case for the rebuttals, Your Lordship. It was an honor. Thank you.
Now I guess we can retire.
Yes, sir. So, thank you, judges, and a big thank you to the teams for your participations in the finals of 5th SURANA and SURANA and CUSAT, Dr. A.T. MARKOSE Technology Law MOOT Competition 2025. We appreciate your efforts and dedication. Now, we kindly request you to leave the meet so that the judges can proceed with the scoring. Once the evaluations are complete, we will notify you to rejoin the meeting for the feedback. So, please stay in touch with the license officers. Thank you once again.
Thank you.